Hello, my name's Olurotimi Osha. Today is August the 20th, uh, 2026. I'm continuing with my discussion on public corruption, and right now I want to talk about a judge's absolute immunity. By the way, I'm going to start with a disclaimer. Um, None of what I'm saying is legal advice, and I'm not licensed to practice law in the United States, in the state of Maryland, or any of the states. Without further ado, I'm going to continue with my discussion on judicial immunity. By the way, let me just put it out there that I do have a Juris Doctor, which is called Doctor of Law degree. I have a Doctor of Law degree from George Washington University Law School, so I'm trained in the law. So I've done a video. All attorneys are lawyers, not all lawyers are attorneys. So I'm a lawyer, not an attorney. So I'm trained in the law. I have a law degree from George Washington University Law School, and I did international human rights law, a program at University of Oxford in the United Kingdom, and I also did international criminal law while I was also an intellectual property law fellow as an exchange student at Bocconi University in Italy. So I'm talking about the absolute immunity of judges, right? So a judge cannot be sued by litigants or parties in his court for his decisions, for his judicial acts, even if those acts are deemed to be charged to be malicious or corrupt, right? That's been established from precedent in the U.S. Supreme Court case Bradley versus Fisher. That's 1872. So a judge is not subject to civil action from his judicial acts, while serving as a judge, in his function as a judge, by, so this protects a judge from civil action lawsuits by parties in his courts, disgruntled or dissatisfied parties, whether they're plaintiffs or they are defendants. It doesn't matter, even if the judge was found to have been corrupt, or he acted maliciously, or he acted in error, right? So he's protected from civil action. So importantly, so long as those the judge's actions were not administrative, or they were non-judicial acts. An example of a non-judicial act, there was actually a case of a judge who was irritated by a defendant, right? A defendant in his court, and the judge, so angry, he took off his robe, stepped out of his pew, right, out of his seat, and then went and he bit the defendant, right? He bit the defendant. So that's a non-judicial act. There's a viral video of a judge who walked out of his court, still in his gown, right, in his robe. He walked out of his court and he went to drag a black woman who was walking out of court. He walked out himself and went to drag her back into court, dragged her as she's screaming. So that's a non-judicial act. So the judge who actually bit the defendant had to spend 5 days in jail and did probation. So those are non-judicial acts. So a judge going to arrest personally, apprehend a defendant, laying their hands on defendants, those are non-judicial acts. So they're liable to suits, in such cases. They're not acting within their capacity. But a judge who is acting within their jurisdiction, or they're doing their role as a judge in sentencing, in hearing cases, and things like that, they have absolute immunity. Even if they did it maliciously or corruptly, even if they collected a bribe to do it, right, they're still not subject to a civil lawsuit by the disgruntled or dissatisfied party in their courtroom. Now that completely goes against, it goes against the grain, right? It sort of contradicts our notions of the rule of law, right? That, well, we said everybody is subject to the rule of law. the government officials are all subject to the rule of law. Yes, indeed they are. But the reason why judges have absolute immunity is so that they are not intimidated in their role by potential blowback from decisions they give in good faith, right? It's very probable, and it happens a lot, that a judge might find an innocent person guilty, might convict an innocent person wrongfully of a crime. Now if that were to happen, then the judge could be liable to trial in the future. So to protect judges from things they're supposed to be doing in good faith, right, from these future trials, like lawsuits and things like that, they have absolute immunity. But again, even an absolute immunity protects them even when they act maliciously. And importantly though, they don't have absolute immunity if they're acting overstepping their jurisdiction. For instance, a judge who is a probate court judge, right? Probate court judge deals with estates, right? Wills and estates, probate, or a divorce court judge. He has no jurisdiction over trying a criminal felony case, right? A murder case, right? So he will be stepping out of his jurisdiction there. So he doesn't have absolute immunity in that regard. So now again, judges are very powerful, and again they tend to abuse their position because of this absolute immunity thing. And of course, one of the challenges, of course, is that judges, just like lawyers, are self-regulating, right? It's their body of lawyers, right? Their organization of fellow lawyers who have a body who review what they do and penalize them if they act wrong and sanction them. The same thing with judges, right? And so there's that tendency that so long as they belong in that old boy network or that network, that their fellow members, their colleagues would not find them, will not hold them to account for violations. Now that is not entirely the case, right? That's not entirely the case, because America, we are a nation of laws. We have our Constitution, and remember, one of the salient reasons why we declared independence, very paramount, and you see it, it's a very consistent, it's very pronounced in the Declaration of Independence, authored by Thomas Jefferson, who himself was a lawyer, right? By the way, everybody in the Committee of Five were lawyers except Benjamin Franklin, right, who represented Pennsylvania. He was a genius, but he was not a lawyer, right? Everybody else was a lawyer. John Adams was a lawyer. John Adams from Massachusetts. Roger Sherman from Connecticut was a lawyer. And of course, Robert R. Livingston was a lawyer and a judge. He was the chancellor, the first person who swore he swore the first judge to swear the first president of the United States, as he administered the first oath of office to the president of the United States. That's George Washington, right? So they were all lawyers except Benjamin Franklin. Now, so holding, these people are colleagues, right? They're peers. How do you hold them to account? Of course, we're a nation of laws, and paramount in the Declaration was the administration of justice, that the King of England was violating the proper administration of justice. His courts were not accountable. They didn't have trials by jury, and people were taken overseas back to England to go and answer for offenses that occurred in the colonies, right, in the Americas, and so they could escape justice, and things like that. So the administration of justice was very important. So we didn't get our independence to let judges act like kings, right? Worse than kings, collect bribes and things like that. So in 1976, in came the public integrity section. Its acronym is called PIN, right? Within the Department of Justice, right? To criminally investigate and prosecute federal judges and federal, state, and local government officials, including judges. And we see it was a public integrity section that did investigate, and they superintended the largest FBI investigation, undercover investigation in history, and the largest corruption sting in the Operation Grey Lord case, in which they charged, right? They indicted 17 judges, and 15 were convicted. One of them three government officials committed suicide. One of them being a judge, Alan Rosen, who was a divorce court judge who had taken hundreds of thousands of dollars in bribes to decide cases in favor of the party who was, the highest bidder, who paid the highest price in divorce cases, to settle divorce cases and disputes. So there is a criminal section that investigates and prosecutes judges, right? And each state, by the way, also has a commission on judicial misconduct, right? I reported judges in Maryland, right, regarding my trumped up malicious prosecution case, right? I was a victim of Montgomery County Police and a perjurer who filed a malicious and perjured emergency valuation petition against me. That's Jide Warire, Howard University professor, and he used his judge friends, Judge B.B. Berry and Judge James Bonifant. And so these, I reported them to the Commission on Judicial Disability. So they investigate and see if there's sanctionable conduct sufficient for them to be able to prosecute a judge. They can refer them for prosecution. So each state has its own judicial commission. In Maryland, it's called the Commission on Judicial Disabilities. And of course, there's also the federal government within the Department of Justice. Now, the public integrity, just in case if you'd like to know, the public integrity section, that's PIN of the Department of Justice, it came about because of the Watergate scandal, in the aftermath of the Watergate scandal, in which the only U.S. Attorney General to have been convicted and imprisoned for acts he committed, while an Attorney General, that's John Mitchell, who was the Attorney General under President Richard Nixon, and he was the person who was bribing and obstructing justice. Of course, he was charged with conspiracy, obstruction of justice, and perjury, and he went to prison, to federal prison for that. So in the aftermath of that, there was a betrayal of public trust. Public trust in government officials declined, it plummeted, and so there was a need to revamp that trust in government officials again, especially judges, right? We don't want judges collecting bribes, running like a cartel and things like that in a free democracy, right? In a democracy that's supposed to be a light, a beacon to the rest of the world, supposed to be an example to the rest of the world. Never mind our constitutional rights, right? When we have corrupt judges, then they will impugn, they will violate our constitutional rights, because then we will not have, our Sixth Amendment rights will be violated. We're entitled to fair trials, right? Fair trials, impartial judges, impartial jury, right? But that would be violated, the Sixth Amendment. And due process, right? The 14th Amendment, depending on the state, and Fifth Amendment if it's the federal. So, interestingly, but apart from that, prior to that, we also have in our Constitution a means of removing judges that behave badly, right? Congress or state legislatures, right? They can, through legislative acts, they could impeach a judge, an erring judge, misconduct. That's very rare. It rarely happens because, Congress, legislatures, they have a lot to do, by the way, right? They have a lot to do. So legislatures can remove judges as well. That's one way. And then again, there's the Department of Justice, which has oversight over federal, state, and of course county government officials. Now, it's interesting. There's several interesting cases regarding judges' absolute immunity, which established them. The first one, like I said, the 1872 landmark case of Bradley versus Fisher. There's another interesting case. It's 1978. It's Stump versus Sparkman. Judge Harold Stump was the judge, and was it Stump? I'll check just to verify that. I think it was Stump. He was a judge, and the situation is very sad, very harrowing. So he approved a mother's petition to have her 15-year-old daughter, whom she called somewhat retarded, to have her sterilized, right? So she had a tubal ligation. She was sterilized anyway. And the 15-year-old girl didn't know. She was told that the surgery she was having was to have her appendix removed. She didn't know she was being sterilized. And later on, about 5 years later or 4 years later when she got married, her name was now Linda Sparkman. She learned that she had been sterilized. She was married, and so she sued the judge. This case went all the way to the Supreme Court. The Supreme Court said, well, the judge was protected by judicial immunity, even though his conduct was contrary to the law, right? His action, his judicial decision, he acted in his capacity as a judge, right? And even though his decision was contrary to law and it was morally reprehensible, the Supreme Court said that he was immune. He had judicial immunity against civil action. So it's unfortunate. I'll do more videos. I want to stop this here. I'll do more videos on judicial immunity of judges. My name is Oluroti Miosha, and I'll keep you posted. Thank you.